Hello, and welcome to the View from Mayor Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners, which highlights developments in case law and legislative changes of importance to UK employers. It is presented by Nicholas Robertson, the head of Mayor Brown's London employment team. The time spent listening to these podcasts can count towards your training requirements. At the end of the podcast, we will explain how to get in touch if you have any comments or questions.
Hello and welcome to 2018. My very best wishes to all of you wherever you're listening to this podcast. Christmas and New Year around our place was momentous. My youngest son turned 20 just after New Year. So as my wife pointed out, she can no longer describe herself as the mother of teenagers, but since I always thought that was a phrase sounded a bit too close to Mother of Dragons and Game of Thrones for my liking, I don't think I'm going to miss that. Anyway, we've got two podcasts coming out in quick succession. This is the first of the ordinary podcast looking at cases that have been decided over the last couple of weeks, or I should probably say reported over the last couple of weeks. I'll come on to them in a minute. Secondly, Miriam Bruce and I, as you know, did the 12 Days of Christmas review of the top 12 employment cases decided in 2017. If you haven't yet had a chance to listen to that, do. It's a really useful review, I think, of the top cases. But we're going to do a short podcast looking at a number of the key cases that are coming our way during 2018. The idea is to give people a heads up on some of the potential developments that we can all look forward to. Well, in this podcast, of course, we're looking at three recently decided cases. The first is about the increasingly important practice of employer workplace audits and what to do when an employee fails to produce right-to-work documentation. Secondly, we've got a case where an individual was put on garden leave and as a direct result lost out on his guaranteed bonus. Was the right to put him on garden leave subject to any sort of implied limitation? Finally, data protection and what I think is a really important case on an employer's responsibility where an employee deliberately and wrongfully discloses personal data about colleagues. As always, please don't forget you can access the podcast. It's via iTunes, it's on the Mayor Brown website, it's on YouTube and the Twitter feed where my handle is Nicholas ROBER11, and that's where we put out the links to the cases. So, first case, Baker and Abellio London Limited. This is an EAT decision. It features an appeal by the employee against the decision of the Employment Tribunal that he'd been fairly dismissed. The case stood out for me because we've now seen a number of employment audits where we've been asked to review right-to-work documents for a workforce. This is obviously increasingly important, and with significant penalties under the Immigration, Asylum and Nationality Act 2006, it is a matter of concern for all employers. And you don't need me to tell you that Brexit is likely to make this situation more fraught than ever. Here, the individual was a bus driver working for the respondent. He'd worked for them since 2012, and he is a Jamaican national. He's lived in the UK, however, since childhood, and this is very important, it was accepted by all parties before the Employment Tribunal. Indeed, it's never been disputed. He has the right of abode in the UK under the Immigration Act 1971. The respondent also recognised that he had a right to work in the United Kingdom. Keep those facts in mind. Following an unrelated problem with another employee, the respondent decided to do a workplace audit. They identified a list of documents which they asked employees to produce to demonstrate their right to work in the United Kingdom. The claimant was asked to produce his passport, but explained that it had expired some 12 years earlier. When he was asked for his right to work documents and failed to produce them, he was then sent home without pay. The company then loaned him some money so he could apply for a passport. However, they also told him he would also require a visa to prove he had the right to work in the United Kingdom. He, on the other hand, said all along, because he was a UK citizen, he had the right to work here and didn't need to go through this process. The employer got in touch with the Home Office and then, according to the employer, the Home Office's advice was that whilst the individual had the right to reside and work in the United Kingdom, the current documents did not provide the employer with, quote, a statutory excuse, unquote, to allow him to continue working for the company, which is slightly odd phrasing, I think you'll agree. Although the employer suggested to the employee how he could obtain the necessary right to work documentation, he did not try to get this. Partly, he said, because he didn't need to, and partly, he said, because he couldn't afford the cost of it. The Employment Tribunal accepted, under Section 15 of the Immigration, Asylum and Nationality Act 2006, that the employer could not continue to employ him without contravening its obligations under that Act. Section 15 in particular states It is contrary to the Act to employ someone who is subject to immigration control if you've not been granted leave to enter or remain in the UK, or that leave is invalid or has expired. The sanction is a fine, but the employer is excused from paying that fine, quote, if he shows that he complied with any prescribed requirements in relation to the employment, unquote. And that's a reference to obtaining the necessary right-to-work documents from the employee. On that basis, the Employment Tribunal decided, when the claimant was dismissed, that the dismissal was in accordance with the Act, the Nationality Act 2006, and as such it was a rare example of a dismissal being fair on the basis that his employment was in contravention of an enactment, and that's the Employment Rights Act, section 98(2)(d). Alternatively, the tribunal said that it was a fair dismissal on the basis that there was some other substantial reason justifying the dismissal, an SOSR dismissal of course, i.e. it was the employer's belief that this documentation was required and that employment could not continue without those documents. I'm going to look at each of those reasons in turn, as both of these were then subject to appeal. First of all, the EAT pointed out that they consider the Employment Tribunal had misconstrued the Immigration, Asylum and Nationality Act 2006. They pointed out that it's only an offence under Section 15 to employ someone without permission if that individual is, quote, subject to immigration control. Section 25 of that Act provides that someone is subject to immigration control only if they require leave to enter or remain in the United Kingdom. There's common ground here, remember, that the claimant had the right of abode in the United Kingdom. It followed he was not even subject to Section 15. Secondly, the court pointed out as well, the offence is employing someone who has no right to work here. The offence is not employing someone without the correct documentation. The right to work documentation is a defence to a penalty claim against the employer. Therefore, it could not be an offence under the Act to fail to obtain the documentation. Therefore, the dismissal by the employer under Section 98(2)(d), contravention of enactment, that could not be a fair dismissal. That left the second, alternative ground to justify the fairness of the dismissal. There doesn't seem to be any dispute that the employer genuinely, but wrongly, thought that Section 15 required it to obtain the documentation for employment to continue lawfully. Did this belief enable the employer to justify the dismissal? Here the employer accepted that a genuine and erroneous belief by the employer, i.e. that it needed to obtain the documentation, could potentially be a fair SOSR reason for dismissal. However, the EAT overturned the tribunal's finding the dismissal was fair on this ground. They sent it back to the Employment Tribunal to reconsider matters. In essence, the EAT felt the tribunal, having come to the wrong decision on the interpretation of the Act, had gone astray when considering the fairness of the dismissal on this alternative ground. The EAT also considered there was a lack of evidence provided to the Employment Tribunal about what was said by the employer to the Home Office, which led the Home Office to, apparently, advise wrongly that the right to work documentation was required for this claimant. That part of the case continues and, presumably, could go either way. I do think, however, it is particularly relevant for employers to look at what the tribunal has said in this case about necessary evidence. If you're going to run a defence that says, quote, well, we may have got the law wrong, but we genuinely thought on reasonable grounds this dismissal was necessary. Clearly, employers are going to think carefully about how to provide the best evidence to explain their thought processes, and that obviously is going to be something that is directly an issue for the respondent here. So standing back from this, where does this leave us? Well, first, employers need to focus on the substance of the right to work in the UK, rather than only treating this as a tick-box exercise. Here, the employer had the right to live and work in the UK. This is never disputed. The fact that documentation proving this was not forthcoming was, in the circumstances, neither here nor there. It was not a legal requirement for the employer to have the documentation. It was a legal requirement for the employer only to employ someone who had the right to work in the United Kingdom. Secondly, if you're designing an audit process, the natural step is to ask employees to produce proof of right to work. Now, it may be very sensible to ask all employees to prove right to work, so there's no suggestion of a discriminatory approach because you're singling out particular employees. But if the employer selects only certain categories of employees to provide documentation, how are you going to go about that? Well, you're going to go about that presumably on the basis of making certain assumptions about who might or might not have the right of abode here. Thirdly, however, where employees do not provide documentation, there needs to be a nuanced approach, and more nuanced than was adopted in this case. In the light of the fact the employee here was not subject to immigration control, individuals who are able to establish that satisfactorily should not face disciplinary sanctions for failing to produce right-to-work documentation. I also think it would be prudent to go through a fair process with the employee before dismissal, and this is one of the facts that actively counted in favour of the respondent in this particular case. And clearly it's important that employees have the chance to explain themselves so that it's clear why they are not producing the right to work documentation, and also it's a chance for them to understand why it's a problem and what can be done to clarify or resolve matters one way or the other. So that's the case of Baker and Abellio London Limited. Next up, Faeta and ICAP Management Services Limited. This is a really interesting case dealing with guaranteed bonuses and garden leave. The claimant worked for the defendant for a number of years. His final contract with them started in 2012 and was for a 5-year guaranteed minimum period. So that's going to expire in September 2017, or it would have done. He was also guaranteed a minimum bonus of £200,000 a year, and then there were arrangements for additional revenue bonuses if his revenues exceeded a particular amount. After less than 2 years on this 5-year contract, the claimant was put on garden leave. The garden leave period lasted from July 2014 to July 2015, when he was dismissed in breach of contract by the employer. Although the case covered a number of issues, the bit I want to focus on is the allegation by the claimant that putting him on garden leave so as to deprive him of the guaranteed minimum bonus was a breach of contract. The contract itself was very clear. It was made absolutely plain that if the individual was on garden leave, he would not benefit from any bonus arrangements. The company had an absolute discretion, according to the clause in the agreement, to put the employee on garden leave during the notice period. Now, how did the employee then try and claim that there was a breach of contract caused by putting him on garden leave and thereby depriving him of the guaranteed minimum bonus? Well, the first thing he said was that although the contract said that he would put on garden leave and would lose his bonus, the letter sending him on garden leave said that he would receive salary, as defined, and, quote, your benefits in the usual way, unquote. But benefits was not a defined term. Now, that was not in line with the wording in his contract. He claimed this therefore meant there was a separate right under the letter for him to have the benefit of his guaranteed minimum bonus payment. It was, after all, a benefit to him. Well, the judge accepted in principle a bonus was a benefit in the context of this contract of employment, however, with a clear distinction between benefits on the one hand and salary and bonus on the other. It was clear that the garden leave letter did not purport to give rise to guaranteed minimum bonus payments during his garden leave period. Fine. Nothing daunted, the employer tries again. He claims that the discretion to put him on garden leave was subject to an implied limitation because the employer's discretion, should not be exercised irrationally or perversely. Well, the court broke this down into 2 tests. First, was it correct to assert that there was not an absolute discretion for the company, as the clause said? It was a discretion that could not be exercised irrationally or perversely. Well, and if that was the test, irrationality or perversity, had the employer complied with its duties, given the employer had placed the employee on garden leave for 15 months so as to remove the entitlement to guaranteed minimum bonus during that period? Well, the court agreed with the employee that there was an implied limitation on the decision to put someone on garden leave. The employer did not, contrary to what was said in its contract, have an unfettered and absolute power to put someone on garden leave for any reason, good, bad or indifferent. The test was whether the employer, before it put the individual on garden leave, had taken into account all necessary matters before coming to a decision. And secondly, was the decision so outrageous that no reasonable decision-making employer could have come to that decision. If it failed to take into account the right matters, or it had reached an outrageous decision, then that decision could be challenged. However, having got over that part, the claimant lost on the actual challenge when applying those legal standards, irrationality or perversity, to this decision. Court said it was a, quote, high hurdle, unquote, for the claimant to get over. The employee is entitled to a bona fide and rational exercise by the employer of its discretion, said the court, but the court also said there was, quote, little scope for intensive scrutiny of the decision-making process, unquote, by the court. In other words, employers are, by and large, likely to act in their own rational best interests. It was absolutely clear here the financial performance of the employee's desk had deteriorated significantly. The employer took a number of steps to try and cut expenses. Other employees were asked to vary their contracts. The claimant here refused to vary his contract by giving up the guaranteed minimum bonus. It seems that other employees were asked to give up differing amounts or differing percentages of their salary. However, it was absolutely clear that the reason the individual was sent on garden leave was because of the declining financial performance, and because putting him on garden leave would allow the company to save significant sums of money, and that was upheld by the court, and so in the circumstances it was not irrational or perverse, and the employee's claim failed. To that extent, the employer's needs were not outweighed by the impact on the claimant, as things such as the atrophy of his skills and his reputation suffering by being on garden leave. I think the case is really helpful for a couple of reasons. First, even though the contract said there was an absolute right, it is still a right, we know, which needs to be exercised in the correct manner. Therefore, employers need to be able to articulate the reasons for sending someone on garden leave, and it follows from this that if they do give reasons to the employee before putting him on garden leave, they need to have thought about those reasons, because they will undoubtedly be held to them if there is a subsequent challenge. Secondly, however, here we have a particularly stark example where the employer's decision was nonetheless upheld. The employee was given a guaranteed minimum bonus, and then less than 2 years later was sent on garden leave, so as to save costs by depriving him of that guaranteed minimum bonus. The court accepted this was a legitimate exercise of the employer's powers. Consequently, where there's a clearly drafted contract, as here, I think it makes it all the tougher for an employee to argue that there has been an irrational exercise of that employer's discretion. Finally, and this really hardly needs saying, employers sending an individual on garden leave need to make sure that the covering letter sending the individual on garden leave doesn't inadvertently give rise to any additional rights for the employee that are not provided for in the contract of employment during the garden leave period. So that's the case of Faeta and ICAP Management Services Limited. Finally, various claimants and WM Morrison Supermarket PLC. This is a case concerning data protection which has implications, I think, for all employers. It's going to go on appeal, so we've certainly not heard the last of this case. In essence, it's a data protection claim, and it concerns the question of whether an employer is liable, directly or vicariously, for the criminal actions of a rogue employee who discloses personal information on the web about co-employees. Claims here were brought under the Data Protection Act 1998 and an action for breach of confidence and an action for misuse of private information. The judgment is a long one, so I'm just going to pick up a couple of points from it. In essence, the individual was a senior internal auditor for Morrison's. As part of his role, he was entitled to have access to a certain amount of personal data about employees, which was sensitive personal data and which was confidential. He became disaffected for various reasons, because he felt he was unfairly disciplined for something. A couple of months later, the external auditor asked Morrison's to provide certain payroll data for audit purposes. The individual was asked to handle the transfer of data to that external auditor. The data was originally stored on a secure system, PeopleSoft, and the data was extracted for him off that system and given to him to give to the auditors. He did not have the right to access it directly. He was given an encrypted USB stick, which he then downloaded onto his own work computer before loading it onto another USB stick and forwarding the data onto KPMG, as he had been asked to do. Critically, he did not delete the data, the personal data that was sitting on his computer. A couple of weeks later, apparently, he uploaded all of this data onto the web, posting it under the name of another employee. To finish his story, he's currently doing 8 years for fraud. Well, what about the rights of the individuals whose personal data had been wrongly disclosed? Well, they brought claims against Morrison's, arguing that Morrison's was the data controller and that this was a significant breach of the data protection principles. Alternatively, if Morrison's was not the data controller, it was vicariously liable for the wrongful actions of the employee concerned. The court accepted that Morrison's was not the data controller at the relevant point. At the point at which the individual was loading the data onto the website, he was controlling the data and he was deciding what to do with it. Similarly, although the court accepted that Morrison's should have been more hands-on in ensuring that personal data uploaded onto an employee's computer was then deleted by him as soon as the information was no longer needed, this didn't actually cause the loss. The individual would have set out to circumvent any precautions, given that this was not inadvertent breach, it was deliberate and knowing breach designed to cause problems for Morrison's. Similarly, the direct actions against Morrison's for misuse of private information and breach of confidence also failed. Well, that left the claim for vicarious liability. Well, first of all, the judge accepted that the concept of vicarious liability existed under the data protection legislation, and also that the employer could be vicariously liable under the misuse of private information or for breach of confidence. The test for whether an employer is vicariously liable for an employee's wrongful actions was set out in cases such as Lister and Hesley Hall Limited. Is there a sufficient connection between the employee and the wrongful actions such that it would be just and fair to hold the employer vicariously liable? Here, the court accepted there was a sufficient connection. The employee had been given access to the data through work and had been deliberately trusted with that confidential information. He had used another employee's data to post the information on the web. His motive in doing so was not relevant to the decision as to whether or not there was vicarious liability. The case is continuing. First of all, the court will actually need to go forward and assess the damages, but bear in mind that under the Data Protection Act, it is not necessary for the claimant's employees to show any loss has been caused by the breach. There's a claim for distress. Secondly, this case has got worrying implications for employers. Here, an employee deliberately set out to break the employer's systems and cause problems to the employer. This is about as far away from any act that the employee was authorised to do as it's possible to imagine. Secondly, what's an employer to do about this risk? Although the company could have been more hands-on when it came to deleting the information from the individual's own computer, the court found this failure did not give rise to the loss. In other words, Morrisons had, in reality, been extremely unlucky when being asked to carry the can, even though they were completely innocent of any actions giving rise to damages. Equally, as the court is aware, given that the employee's actions were designed to cause problems for Morrisons, the court, by passing vicarious liability to Morrisons, is actually furthering the employee's wrongful aims. And given that we're talking about something like 100,000 employees, the potential damage here is potentially very significant indeed. As I say, that case is continuing, and we'll intend to come back to it when we know what the Court of Appeal have to say on these issues. So that's the case of various claimants and WM Morrisons Supermarket plc. Thank you very much for listening to this, the first podcast in 2018. I hope you found it interesting. We're back up and running in the normal way, and so in a couple of weeks' time we'll be back with another 3 cases, just in time for my birthday. But in the meantime, as always, it just remains for me to confirm that no employees or teenagers were harmed in the making of this podcast. Thanks very much.
So that was our latest podcast. We hope you found it useful. If you have any questions or comments, please email Nick on nrobertson@mayorbrown.com. Our podcasts are an overview of cases. How the law applies in any particular case will obviously depend on the individual circumstances, so please take legal advice if any of the matters discussed are relevant to issues that you are dealing with. And thank you for listening.